Now we move to the technology transfer regime, which is composed at the EU level by a block exemption regulation and accompanying guidelines. The current regime dates back to 2014 and is actually, as we will see, under revision. But I would say that if a person is approaching the issue of the interplay of IP and competition law in Europe, like if they really approaching the issue from scratch, the first document to be read, I would say, is the technology transfer guidelines. I mean, it's really let's say symbolic, an example of how they are, like the current understanding sees IP and competition law as complementary, and so the relevance goes much beyond simply technology transfer agreements and can have a broader relevance. Also, here there's not much enforcement, not much cases, so I will mention some cases concerning licensing, but they're very old. Sorry, Andrea, but there's nothing more recent from the EU course than what I will mention. But at the same time, something that perhaps is not so known is that the fact that an agreement is either block exempted or individually exempted doesn't mean that, like beneath, the same agreement cannot constitute an abuse of dominance. And so this is like an old case, is the Tetra Pak first case. So Tetra Pak is famous for the second case of the mid-90s about rebates and tying, if I'm not mistaken. But the first tying, but the first Tetra Pak case concerned an abuse of dominance by acquiring an exclusive license to a patent. And so in that case, Tetra Pak bought essentially a competing undertaking that had an exclusive license to the only competing technology to Tetra Pak Swan for creating aseptic packages for milk. And the commission investigated the case, and Tetra Pak defended itself. Look, my agreement, like this agreement, this exclusive license agreement is block exempted. And the court was just established the court of first instance back then. I mean, highlighted the fact that even if an agreement is block exempted, doesn't mean that it cannot constitute, can exclude the application of Article 102. So in this sense, what we are going to say about patent licensing is going to be relevant also in 102 cases. This is the gist of it. So we are briefly overviewing the interplay of IP licensing and new competition law, so the current economic understanding. Then going over the technology transfer block exemption regulation, passing to the guidelines on a specific type of agreement that is technology pools. So these guidelines talk about technology pools, but you might be more familiar with the name patent pools, but essentially they are synonym. And we will finish with an overview of the review of the current regime, which is expiring mid next year. And so the Commission has already started for a while now the revision process. And we are expecting a draft new version of the block exemption by summer this year. So IP licensing and EU competition law. Why IP licensing? Well, essentially technology transfer in the understanding of the Commission coincides with IP licensing agreements. So the consideration is that IP licensing, so the agreements concerning the licensing of IP, are very often pro-competitive. They allow to reduce duplicated R&D investment, promote innovation diffusion, so promoting the diffusion of technologies beyond just the original inventor, let's say, and in this way also allow follow-on innovation, create freedom to operate downstream in downstream markets, and in this sense also reduce litigation and other benefits. At the same time, there can be restrictive effects, and this is not really coming from licensing itself. Like specific clauses can lead to restrictions of competition. And again, as Giorgio almost always highlighted in the cases he mentioned earlier this morning, I mean, the restriction of competition, even in the licensing agreements, are linked to some existence of market power. And this is, let's say, also underlined by the approach taken by the technology transfer block exemption regulation. So you can have, for example, licensing between competitors, so firms competing, for example, because they hold alternative technologies or because they are competitors in the product market. Well, licensing agreement between competitors can lead to less, for example, inter-technology competition. But even vertical agreements, so licensing agreements between technology supplier and a downstream product manufacturer that is not a competitor, like these parties are not competing directly. I mean, also these types of agreements can lead to some restriction of intra-technology competition. There can be foreclosure effects. Some clauses, and these are those that are so-called excluded, especially excluded restrictions in the current block exemption regimes, can diminish licenses for law on innovation incentives. And these are like what was already mentioned by Maria, for example, grant backs clauses, when they are exclusive, they can especially lead to this diminution of follow-on innovation incentives. Also, there can be some oligopoly, let's say, effects, creation effects of parallel networks of licensing agreements that can increase transparency in the market, align incentives, and so lead to coordination, if not collusion. So against this background of positive and negative effects of competition, stressing the fact that generally, though, the pro-competitive effects prevail, and so licensing generally promotes innovation, like the TTBER regimes at the same time compromising like this general benevolent effect for licensing with the need to also protect competition, which is, as we have seen also yesterday, is an essential driver too of innovation. And in this sense, the current block exemption regime considers that, okay, parties to licensing agreements need to recoup investment. So, for example, a licensor might have pursued several lines of parallel R&Ds and only one being successful. And so the pricing of the licensing of the successful technology coming out of the several R&D project might not just reflect the cost of that single project, but he needs to recoup also the money spent and investment done in the other failed project. At the same time, the licensee invests to a certain extent in the in-licensed technology, and so he has also an interest in protecting his investment in the technology itself. And then another consideration is that we can be less skeptical of licensing when it is, in a certain sense, a vertical agreement, so an agreement between non-competing parties compared to an agreement between two competing parties. So an agreement between competitor, an horizontal agreement. And because of this, let's say, of this background, of this consideration, I mean, with the TTBER regime, we have quite a wide block exemption with a limited list of restrictions that are considered either in the blacklist of our hardcore restriction and or in the gray list of excluded restriction. And as the other block exemption that you heard before, I mean, this is binding legislation directly applicable by the Commission, the authorities, national authorities, but also by national courts. In parallel with the block exemption regime, also here we have guidelines, so TTG, technology transfer guidelines, and these provide both guidance on applying the block exemption regime and also assessing outside the block exemption licensing agreements, also beyond the technology transfer ones, so outside the scope of the block exemption. So the guidelines are really something, I stress these are really quite an advanced understanding of IP and EU competition law, and if you have not done so, I encourage you to read them. Of course, the guidelines are soft law, so non-binding, especially on courts. Because of the principle of legitimate expectations, particularly, I mean, the guidelines are binding on the Commission itself, which adopted them, but still they are very authoritative, also for courts. Finishing with the overview of IP licensing and EU competition law, a bit of a historical overview. I don't think that anybody here is old enough to remember the 1962 Christmas message. So the first time that back then high authority, I mean, I don't know if it was already commissioned, Giorgio, but the first time that what is now the European Commission addressed the issue of IP licensing and competition law was in 62, and this was really like soon after the adoption of the first implementation regulation 17 of 62. And with this Christmas message coming out just before Christmas of 1962, like the Commission wanted somehow to provide some level of legal certainty about generally lawful clauses in patent licensing agreements. And so this was really a list of what was considered green-lighted under EU competition law. Then we moved to a few years later, and with the empowerment regulation, which is the regulation that authorizes the European Commission to grant in general block exemption regulations, and in particular there is the competence for the Commission to grant block exemption to bilateral IP licensing agreement. And with this empowerment regulation, we moved to the first block exemption concerning just patent licensing agreement in 84. Another separate block exemption for know-how licenses, so patents and know-how were treated in separate legal documents. And just in 1996, we have the first so-called technology transfer block exemption regulation, which comprises more types of IP rights. So not just patents and know-how, but also other types of IP rights that are defined as technology rights. And then with the we moved to the, let's say, Regulation 1/2003, and so shortly thereafter, we have the revision of the TTBER, and the first time that we have accompanying guidelines, and the current one, the one of 2014, which is currently under review. And in general, I mean, especially under the first implementation regulation, of course, block exemptions were really important because they allowed the Commission not to receive notifications of agreements and assess them, while now these block exemptions are, with the more economic approach and the decentralization, these are, let's say, mostly used by companies and lawyers for self-assessment of their compliance with competition law. Any questions so far? Who knew about the Christmas message? I mean, this is okay. So moving to the current regime, as I said, I mean, the analysis is quite advanced, and it can be helpful also beyond Article 101 cases. Like if you are dealing with an Article 102 case, alleged exploitation in patent licensing agreements, you can still find the useful information into this block exemption regulation. So, I mean, you know, block exemption regulations, as the word says, exempt in block certain categories of agreements that, in a certain sense, have a presumed net positive impact on competition. And any block exemption regulation adopts essentially the same structure. So market share thresholds. So in this sense, we are concerned that the parties involved in the agreements do not have market power. neither individually or jointly. And also in parallel to the fulfillment of market share thresholds, also we are concerned about specific clauses, the hardcore clauses, what they were called the blacklist clauses. And again, as with the any other block exemption, I mean, the European Commission and even national competition authorities, in special cases, can withdraw this benefit. And this would come with an ad hoc regulation, though. Just to have a broader picture of all block exemption regulations, I mean, think of the innovation process itself. So, I mean, we know, I mean, it's quite intuitive, but innovation starts with basic fundamental research. And then after fundamental basic research, you can have applied research. After applied research, you have development, so research and development. After the development, and so proof of concept, prototyping, you have the implementation of the technology into a product. Then this product is diffused in the market and distributed. And so here, somehow, what Maria talked about earlier, the R&D block exemption regulation, concerns more or less the first up to four stages of this innovation process, summarized, let's say, while our focus with the TTBER, the Technology Transfer Block Exemption Regulation, is just on the implementation and diffusion of technology. Then, of course, I mean, there are other block exemption regulation. For example, the vertical block exemption regulation is really focusing on distribution, while a less known but important block exemption, which is the specialization block exemption, is concerned with manufacturing. Okay. So coming to the scope of the block exemption, first of all, the focus is only on technology transfer agreements. And this is like somehow a complex definition of two otherwise straightforward types of IP agreements. First of all, licenses of technology rights for production purposes. And then as a residual category, I would say, assignments of technology rights always for production purposes where the assigner keeps part of the IP exploitation risk, so keeps a financial interest in the transferred IP right. And again, I mean, there is a specific article in the TTBER that makes it explicit that the TTBER applies after the R&D BER and specialization BER do not apply. So in case of licensing of IP rights within for example, joint R&D agreement, I mean, the instrument that you need to use is not the TTBER, but you have to look at the R&D BER. An important limit to the scope of the TTBER is that it concerns only bilateral agreements, so not multi-party agreements. And this is due to the empowerment regulation that we mentioned up front, back to 65. At the same time, I mean, the Commission tries to provide some level of legal certainty and clarification with the accompanying guidelines. And the only, let's say, agreement, multi-party agreements that is addressed there is the one of technology pools that we will see at the end of the presentation. At the same time, I think one issue that is lacking and can lead to uncertainties in the application of the TTBER, which is simply focusing on bilateral agreements, is the issue of the joint ownership of IP rights, especially in the case of inventions. I mean, often like inventions are the results of joint efforts, common efforts, joint R&D agreements. And so in this case, what if the IP right is jointly owned by more undertakings and then out-licensed to another undertaking? Well, like strictly speaking, I mean, the block exemption would not apply, but I mean, the analysis would still be, should, in my opinion, should still follow the same principles. Always on the scope of the agreements, the TTBER applies both to so-called reciprocal licenses and non-reciprocal licenses. Reciprocal licenses are those cross licenses, so where like the two parties grant each other access to the respective IP rights. But in this sense, the limitation is that the cross licenses concerns substitute technologies, so alternative technologies. And you can understand that these reciprocal licenses are the most troublesome for competition law, no? Because you have competitors essentially cross-licensing each other. While non-reciprocal licenses can be either unilateral, normal licenses, one party to another, not two ways, let's say, but also they are considered cross-licenses of non-substitute technologies. So cross-licensing or of complementary technologies. And in this sense, think of standard essential patents, like where like two SCP holders grant each other a cross-license. I mean, because we consider that standard essential patents are necessarily complements, this is going to be considered not the most problematic type of agreement, but the least problematic, the non-reciprocal one. Okay, always on the scope. We said bilateral agreements. Now, what type of IP rights are included? I mean, the regulation talks about technology rights. And these are defined as know-how, patents, utility models, design, software copyrights, topographies of semiconductors, supplementary protection certificates, and new plant varieties. So one interesting point is that the regulation, because it dates back to 2014, it precedes the Trade Secrets Directive, and so talks about know-how and not of trade secrets. And somehow there is a discrepancy between the concept of know-how in the block exemption and the concept of trade secrets. And so this is one of the issues that we are expecting the Commission to update, let's say, the definition of changing the definition of know-how to trade secrets. Also, a specification of the scope. I mean, the IP rights must be either granted or pending applications. Since I mean the first technology transfer block exemption regulation, I mean the agreements can concern mixed rights. So the block exemption can apply to agreements that involve both patents and know-how together, while before, I mean, also because the block exemption were separated, it was more controversial whether the exemption could apply to mixed licenses of more of one type of IP right. Regarding the duration of the block exemption, I mean, the exemption lasts until the IP are in force. And in this sense, expiry or invalidity of the IP right subject to the license agreements and the exemption. And in this sense, we can draw an analogy to two cases, mostly the Kai-Ottung quite old case from the late 80s and the more recent Genentech case, which involved companies like granting licenses for patents, for patented technologies. And these licenses obliged the licensee to keep paying royalties even after the expiry of the patent or the invalidity or the finding even of a non-infringement. So in this sense, I mean, this clause was challenged as unfair, as exploitative, so having to pay for something, for an IP right that was found to be invalid. But the quite advanced economic understanding of the Court of Justice actually recognizes that in certain cases, I mean, these clauses are not necessarily unfair. Still, if you think about it, during the time of validity of the IP right, you have enjoyed some level of protection or of exclusivity in the market, perhaps because you were perhaps the only one having lawful access to the IP right itself. And so perhaps the way of structuring the payments even after the expiry or the invalidity of the patent is simply a financial way to dilute the payments over a longer period of time. So in this sense, I mean, for the court, this type of clauses extending the payments of royalty after the expiry of the IP right are not necessarily unfair, especially, I mean, if the licensee can terminate the license. I mean, if at any given point the licensee can terminate the license, I mean, until he doesn't do so, he will be obliged to pay even for the expired IP right. Then on the scope, I mean, you have noticed that among the technology rights, there is no mentioning of trademarks. But at the same time, I mean, trademarks are not really related to technology, as we know. But thanks to Article 2, Paragraph 3, I mean, there is the possibility of still exempting ancillary provisions on the purchase of input or the licensing of trademarks, which are directly related to the production or sale of the contract products. So if the technology is also covered by patents, I mean, is given is subject to a licensing agreements, and together with the patent, there is also a trademark covering the name of the technology. I mean, that type of licensing concerning the trademark will be block exempted as an ancillary provision. A specification is that software copyright licenses for the mere reproduction or copy of the software are excluded from the block exemption, also because they are more resembling distribution agreements. Then coming to the safe harbor requirements, first of all, we have the market share threshold requirements. So parties need to have a lower threshold than that set by the regulation. And also the agreement must not contain any hardcore restriction. If we find that the parties have market share thresholds higher than the one of the regulation, or if there are alternatively hardcore restriction in the agreement, this doesn't mean that the agreement is unlawful. It simply means that it's not block exempted, and in this case, it needs an individual assessment. What are the market share thresholds? Of course, because we talk about IP rights, IP licensing agreements, remember like yesterday class that there can be a separate upstream technology market for the licensing of the IP rights, and then a downstream market for the products implementing the licensed technology, or the alternative products implementing alternative technologies. And so the block exemption regulation considers market shares on both markets, both the downstream product market and upstream technology market. As usual, the shares are based on previous year data. And there is a distinction, though, between agreements that are horizontal between competitors. And in this case, if the parties to the licensing agreements are competitors, together, their market share must be below 20%. So one can hold 19% of the market and the other one 1%, fine, but no more. Instead, if the parties are operating at different level of the value chain, if they are not competitors, the individual market shares can be up to 30%. So we can have a company holding 30% on the relevant, let's say, upstream technology market, and the licensee holding 30% on the product market. Also, the exemption is market specific. So, and the exclusion is really specific to each market where the shares are exceeded. So think about, again, the licensing of a standard, an industry standard technology for, I don't know, Wi-Fi. And so you have a licensor, which is below, the parties are not competing. Let's say the licensor holding some standard essential patent over Wi-Fi, and then you have a non-competing licensee that both does smart meters and smartphones, let's say. And so the agreement like is for the licensing of Wi-Fi both on the product market of smart meters and on the product market of smartphones. And in case the licensee exceeds the threshold on either of the two product markets, I mean, in that case, that part of the license agreement is not going to block exempted. The block exemption really applies only to, like, is market specific. So the market shares must be respected on the specific product market. And in any case, do not worry, even if the parties exceed the thresholds, there is still, let's say, some time to adjust and take countermeasure for the exclusion of the block exemption, because the parties have 2 years after the year exceeding the threshold to still benefit from the block exemption. Of course, and this is one of the most problematic issues of the technology transfer block exemption regulation, it's very hard to define technology markets. It's very hard to calculate market shares. And so as an alternative and as a subsidiary method of assessing these agreements, in the technology transfer guidelines, you have a rule, the so-called 4+ rule, which still, in case of doubt about the actual market shares, because you lack information, because you don't know exactly what the other companies are holding in terms of technology, which is usually, I mean, kept secret, is not something that you go and post online. I mean, the guidelines tell you that if, besides the technology involved in the agreement, there are other 4 independently controlled technologies, so in the market there are at least 5 technologies competing among themselves. In this case, it's very unlikely that the agreement, the licensing agreement over that specific technology can raise competition law concerns. So this is, let's say, a safety valve against the difficulty of defining relevant markets and calculating market shares. I want to stress a bit market definition, technology market definition, on certain issues that were not touched yesterday, because you can really find most of information about technology market definition in the technology transfer guidelines. If you are judging a standard essential patent case, if you are involved in an abuse of dominance by a standard essential patent holder, and you want to a bit dig deeper into the assessing, defining the relevant market, I mean, I urge you to have a look to the guidelines. And so technology market we saw yesterday are markets where the intellectual property is licensed as an upstream input separately from the downstream implementing products. And this concept is, let's say, common to any modern competition law. In US antitrust law has the same concept. And this technology market has both a product dimension and a geographic dimension. So as usual, with the product dimension, we look at the substitution between the licensed intellectual property right. And in this sense, you can have other proprietary technologies that are substitute to the one subject to the license, or you can also have technologies that are in the public domain. And how you judge substitutability? Usual issue of market definition, the features of the technology, the price of the technology, and the intended use. But at the same time, like judging substitution between IP rights is very hard. It's not something static or clear-cut. It can really change depending on the circumstances. So think again, I mean, for example, let's simplify to a Wi-Fi patent and a Bluetooth patent. I mean, these are not necessarily always substitute, complementary, or unrelated. I mean, in our mobile phone, we want the both Wi-Fi and Bluetooth technology because we want to connect to anything. But for example, in the smart home system, perhaps you choose a system that only implements Wi-Fi connection, and so your fridge doesn't need Bluetooth. If it's Wi-Fi, it's enough. And so in this sense, for the smart home implementation, the two patents can be unrelated, while, or at least, I don't know, in the having a smartwatch, I mean, we can judge whether or not these two type of technologies are really complements, substitute, or unrelated in any given circumstance. So the assessment is case specific. You cannot decide in the abstract and in advance. And also, if you think of supply substitution of intellectual property, I mean, supply substitution of IP is necessarily imperfect. I mean, you can have some type of legal alternatives when you have exhaustion, but otherwise, IP rights exactly impede imitation competition. So legal alternatives, in theory, are like without the authorization of the IP holder, they do not exist. There can be functional alternatives. So Wi-Fi and Bluetooth for certain uses, like short-term wireless connection, can be functional alternatives. You can have price performance alternatives. So think about 5G and 4G. They essentially do the same thing, but one is 5G is faster, and 4G is lower. But perhaps because of the price of 5G that is too high, an implementer, I don't know, of a smart product that does not need such a fast connection capability, content itself of just choosing the 4G technology. And so in this case, I mean, the alternative, the substitutability depends on the price, of course, of the technology. And also, there is a lot of infringement. And so there can be some level of substitution and competition coming from infringing products. So in this sense, I mean, perhaps it's not so straightforward, but even products that violate the IP right can still constrain to some extent the supply of the licensing of the IP right violated. On the geographic side, because we said the technology market, as any other relevant market, needs to be assessed in terms of product and geography. So geographic dimension is the homogeneous area where the IP supply and the IP demand meet. And of course, we know that in most cases, IP rights are territorial rights. They exist only in the country where they are granted. But technology markets instead are really global. I mean, globalization, I mean, our mobile phones work anywhere. You travel to the US and you don't need to change a mobile phone. It will connect to the network. Same medicines. I mean, the diseases are all over the same. And so the same medicine can travel borders and still be used. So in this sense, there is a tension between the IP territoriality and the global nature of technology markets. Also, the fact that companies usually prosecute patents in every country, in every market that is valuable, and so compose large geographic patent families also enlarge the boundaries of the relevant geographic market for technology. So on market shares, calculation specificities, this is really clearly stated by Article 8 of the TTBER. First of all, in theory, you should look at market sales. So how much are the companies selling? And in this sense, I mean, you have, of course, you must know the overall value of the market, and you know how much a company has sold, for example, in terms of turnover, and then you just apportion the given party market shares compared to the industry overall. If you don't have sales data, you can have sales volume data. So in terms of number of units sold by a given company compared to the industry overall. Then about technology, it's really hard to know about royalties. No, these are licensing agreements are highly confidential agreements, and so it's almost impossible to know what's the licensing revenue for a given technology. Especially, I mean, among competitors, this is something that is kept highly confidential, and so the TTBER provides an alternative method, which is called the footprint approach. And in this sense, just for the case of technology market shares, these shall be calculated because in case you don't know the royalties and so how also the overall market for the given alternative technology is worth, because this uncertainty, technology market shares shall be calculated based on the presence of the licensed intellectual property rights on the relevant contract product market. And so in this sense, for example, the example of licensing Wi-Fi in a smart meter and a smartphone, I mean, the technology market share of the licensor of the Wi-Fi patent will correspond to the product market share of the licensee, both on the product, on the smart meter product, and separately on the smartphone product. So essentially, once you know the licensee market share on the product market, you automatically know the technology market share upstream of the licensor. And there are some specificities about technology market share calculation that are defined by the technology transfer guidelines. So, but what happens, for example, if the parties exceed the thresholds, or if the agreement contains an hardcore restriction, or if the agreement, let's say, is outside the TTBER safe harbor because it's a multi-party agreement, so beyond just two undertakings, there is no presumption of illegality. We said it up front. I mean, in most cases, licensing is pro-competitive. And accordingly, I mean, even outside the safe harbor of the block exemption, they can still fall outside the Article 101, Paragraph 1 prohibition, or even if they have some anti-competitive effects, there can be countervailing efficiencies under Article 101 free, and so benefit individually from the exemption. Of course, you need to do an individual assessment in this case, and here the guidelines are really helpful. And in sense, of course, you have to look at the counterfactual and ask yourself, does the license agreement restrict competition that would have otherwise existed had no license been executed? And then, is any efficiency outweighing the anti-competitive effects? Of course, I mean, parties can complain of their agreement being outside the block exemption because the case-by-case analysis increases the relative cost of entering into the agreement. The lawyers are expensive, and so it's much more costly for a party falling outside the block exemption to be certain with a relative degree of certainty of being compliant with Article 101. So we said that there is also a distinction between competitors and non-competitors, for example, also for the calculation of market share thresholds. And here, again, I mean, this is something that also comes up in the R&D BER. I mean, it's interesting because for the block exemption, for the product market, we consider both actual competition, so parties already competing, being in the same relevant product market, but also potential competition. And here we consider an entry horizon of 1 to 2 years, quite short, I would say.
Just to add, in the case of R&D, that would be 1 to 3 years, a bit more because of the longer expectation of R&D to material.
Of course, here you are closer to the market. We saw in the innovation process, here we are really coming close to the distribution part of the innovation process. So the competitive issues can be like more likely, let's say, than the R&D agreement that is much farther than to the relevant product market. But instead, for the technology market, it's interesting that we only look at actual competition. So we don't care if two parties are potentially competitors on the relevant technology market. I mean, for the purposes of the block exemption, they are considered as non-competitors. And so potential competitors in the technology market are considered non-competitors. And in this sense, they will benefit from the higher 30% market share threshold. A a hard point, let's say, of the block exemption is the fact of the considering two parties non-competitors if they are in a so-called blocking position. Of course, if you have an IP right over a certain product, nobody, let's say, absent, let's say, exception to the IP right itself, but nobody can start using your IP right without your consent. And in this sense, I mean, the IP right is blocking anybody else from entering, let's say, the market, the relevant market around that IPR. At the same time, I mean, this, of course, impedes lawful competition, but you can still have infringing competition. So competitors entering the market and not respecting the IP. But in any case, the taking at face value the validity and the enforceability of IP rights for the purpose of the technology transfer guidelines, two parties are considered non-competitors if they are in either a one-way or two-way blocking position. One-way blocking position means that a party must infringe the other party IP rights, valid IP rights to enter the market. Two-way blocking position is that each party necessarily infringe on each other's IPR. In this sense, think of, again, the case of standard essential patents, like two standard essential patent holders that are also manufacturers are necessarily in a two-way blocking position because they necessarily have to implement each other's standard essential patents to produce the standard compliant product. And for the purpose, it's quite counterintuitive, but these two SCP holders are considered non-competitors because they are in a blocking position. This is, let's say, a questionable issue, a questionable solution adopted by the current technology transfer regime. Very fast on hardcore restrictions. These are the usual no-nos of competition law. The list is a bit more stringent for licenses that are horizontal between competitors. So fixing of prices, output limitation on the licensee, customer allocation, and interestingly also limitation on the use on the licensee own IP rights or restriction on the ability of undertaking R&D, research and development. Between non-competitors, let's say the list is a bit more is shorter and so shows more leniency toward this type of non-horizontal agreements between non-competitors. Coming perhaps to the most interesting part of the excluded restrictions, so which are, let's say, against which we are skeptical in general, but still can be exempted individually. So the entire rest of the agreement can benefit from the block exemption. We sever the excluded restriction and we assess these individually. So the first excluded restriction is exclusive grambacks. So with these clauses, the licensee cedes to the licensor rights in improved new application of the licensed IPRs or even other IPRs unrelated to the licensed one themselves. So before 2014, there was a distinction. I don't know if this is quite a famous issue, but there was a distinction between severable and non-severable improvements. And in this sense, there was, let's say, the exclusion from the block exemption only of grambacks, exclusive grambacks for severable improvements. And the reason here is that if an improvement is non-severable, so needs necessarily to infringe the already like the primary IP right that is subject to the license and is owned by the licensor. I mean, in any case, the licensee will not be able to use the non-severable improvement without the consent, the authorization of the party holding the primary IP right. But in any case, this distinction was very hard to implement in practice. It's very hard to understand whether or not an improvement is severable or non-severable. So for the sake of simplicity, it's abandoned as a distinction. Of course, we are talking just of exclusive grambacks. Parties can still lawfully benefit from the block exemption and undertaking non-exclusive grambacks. Here you have, let's say, some arguments that can, let's say, that motivate the fact that the exclusive grant backs are negative for competition, but still they can still block exempted because they bring certain pro-competitive efficiencies. Second excluded restriction that I would mention is the no challenge clause that you already heard regarding the R&D block exemption regulation. And with this clause, the licensee relinquished the right to challenge the validity or the essentiality of the licensed IPRs in Europe. And the problem with this clause is that we like when IPRs that are invalid are removed from the market simply because bad IPRs, bad quality IPRs should not exist. This, let's say, for this reason, there is this skepticism against no challenge clauses. Also, the same treatment is reserved to like the termination clauses in non-exclusive licenses. But at the same time, and this is also comes from the case law on pay for delay agreements, it is recognized that sometimes no challenge clauses are useful and necessarily to put an end to an infringement dispute. So in settlement agreements, generally, this type of clauses can be is considered lawful under competition law, because otherwise, I mean, the parties, the licensor, the IP owner would never agree to the settlement if the counterparty, the infringing party, could keep, even after the settlement, challenging the validity of the IP right itself. So I would say it's fair to allow this type of clauses in the settlement agreement that puts an end to litigation. Here again, there is, let's say, there are competition concerns, but at the same time, there can still be pro-competitive benefits, and these, let's say, these benefits are also reflected in the case law of the Court of Justice. Again, sorry, there is not much novelty in these. These are cases from the 80s, Windsurfing International and Sulhofer. But in this sense, I mean, also the Court of Justice recognizes that if the licensee is not paying for the IPR, so it's a license agreement that does not foresee any payment, or if the licensee is simply not infringing the IP right itself, I mean, these type of clauses can still be lawful in a license agreement. Any question on the main issues of the block exemption regulation? Otherwise, we move briefly to technology pools. Okay. Yeah, fine. Technology pools. So these are defined by the guidelines as arrangements where more parties, so more than bilateral agreements, assemble a package of IPRs, often relating to industry standards. We mostly see technology pools for standards, so like Wi-Fi or the cellular technologies. And after having packaged the IPRs, they license among each other. So if the contributor to the pool can also get a license, like the benefit of a license to the larger pool, but also to third parties that are outside of the contributors. And there are two agreements underline this, let's say, technology pool. The first one is the framework or master agreement, where the parties holding IPRs come together and agree how to pull together the IPRs, how to share the royalties received by the pool from subsequent licensees. And so also the way that the royalties are going to be shared. And this is really sensitive for competition law if you think about it. So are the royalties going to be shared based on the number of patents contributed to the pool? So I contributed double of your patents, so I should receive double of the royalties of the other contributor. Are we looking at quality factors of the patents? So this is really a delicate agreement. And besides this master agreement, there are, of course, the model, let's say, out licensing agreement from the pool to third parties. So this is actually the concrete agreement between the pool and anybody that wants to take a license to the pooled IPRs. And still, I mean, even if you think about it, I mean, the pool can be a single entity, so a company that does pool technology as a business. We have a famous one based in Italy, Sisvel, that does this for a living. That means simply allows companies to come together, give them an exclusive license with sub-licensing, not non-exclusive license with sub-licensing rights, so pooling their IPRs and then acting on behalf of the contributors in the market. And so, of course, I mean, this is an individual undertaking given a license potentially to another individual undertakings. But for some reason, for the Commission, prevails the fact that the more parties came together in the master agreement and defined how to pull together the technologies, what should be the fee charged to subsequent licensee. And so even, let's say, the agreement between the pool and the third parties is outside the block exemption and is only considered in the guidelines. Why, let's say, does the Commission, since actually the previous block exemption regime of 2014 provides this, let's say, legal certainty to pools? Well, because pools can bring several efficiencies, essentially. They can bring several efficiencies, reduce transaction costs, for example. They can lead to non-discriminatory licensing because the same license is applied across the entire implementers. At the same time, the concern is mostly horizontal collusion among competing or among technology owners. So fixing the price, for example, of the technology itself. So in this sense, I mean, there are both pros and cons, as often in competition law issues, and so we must assess whether or not, let's say, the benefits outweigh the negative effects, and so whether the technology pool is lawful under Article 101. We have, let's say, a list of factors that, if met, entitled the technology pool to benefit of a so-called soft safe harbor. And this only concerns the master agreement for the formation of the pool. And it's a soft safe harbor because it's not in the regulation, it's in the guidelines. And guidelines are soft law, non-binding, and so it's just a soft safe harbor. But essentially, the European Commission has never took action against patent pool ever since having published the guidelines and this soft safe harbor, also because the issues are really complex. You know, patent litigation, how complex it is. You need patent attorneys, court experts often. And so allegedly the Commission doesn't want to touch this Pandora box. And so is happy with this list of safeguards. And you have here a list of factors. Perhaps one that can interest those judges involved in standard essential patent litigation is the factor E. So is explicit in the guidelines that to benefit from this soft safe harbor, the licenses from the pool to third parties should be on front terms, so fair, reasonable, and non-discriminatory to all potential licensees. And so if you are familiar with the issue of whether SCP holders must license anybody along the value chain, or if they can choose where to license in the value chain and rely on other contractual devices for the other levels of the value chain. I mean, in this case, I mean, the endorsement is really to licensing to any possible requester of a license. So some interesting analogy could be done from this principle and the SCP cases, I would say. Then you also have some other factors for, let's say, the pro-competitive treatment of the agreements between the pool and third parties. And essentially, if the market pool, as long as the market pool is not dominant, has not a dominant position, it's unlikely that there are going to be issues in the licensing agreement between the pool and third parties. But of course, I mean, the technology pools are especially successful when they comprise all the complementary technologies. And so they bring the most transaction cost reduction, one-stop shop efficiencies, when they include all the possible IPRs relating to a complex technologies. In this sense, we don't really want to have like 5 patent pools over Wi-Fi. It's better just to have one patent pool for Wi-Fi, but because of the transaction cost reduction, I mean, if you want to license Wi-Fi technology, you just need to go to this one person instead of multiple pools or even more multiple licensors. But so this single pool holding the entire share of IP rights in over a given technology, it's likely to have almost a monopoly over the technology market. And so in this sense, it's important, let's say, that the other safeguards are respected in the agreements. Quickly moving to the conclusion. So as I said, I mean, this regime dating back to 2014 is shortly expiring in 2026. So the revision process has already started. In terms of what was done and where we are, I mean, the evaluation phase, so the first phase of the review by the Commission has ended last year, and early this year started the so-called impact assessment phase. Actually, now until April, end of April, there is an open call for evidence and public consultation. So if you want to contribute, if you have something to say, I'm sure that the Commission appreciate the view of learned judges, so you can do so on the Commission website. But so by summer, you will be able to read a draft revised. We will be able to read a draft revised block exemption and guidelines, and there will be another public consultation on this draft version, and a new regime by the second quarter of 2026. What needs to change? I mean, is the current regime effective? Overall, yes. I mean, the stakeholders are quite happy with the regime. It allows is effective because it allows to exempt in block only those agreements that very likely meet Article 101(3) requirements. The regime provides legal certainty and decrease compliance cost. Is also helpful for competition authorities when they decide whether or not to open a case. And also considering that IP licenses have not changed that much in terms of like contractual drafting since 2014. I mean, the current what's inside is still valid. Also, the main change in the regime occurred between the 1996 version before the modernization of EU competition law and the 2004 version. So let's say the most changes occur between the 2004 and 2014 version are still regarded as effective. But at the same time, the Commission realized that there is really limited enforcement cases compared to other block exemption regulation. And one possibility is that the regime is perfect, and so nobody needs to litigate, but perhaps also the regime is too complex. And so one issue that is for revision and where the Commission is focusing some of its effort is like to simplify or make it more straightforward the way that relevant technology markets are defined and the way that market shares are calculated. Also, I mean, we are expecting, let's say, to account for the developments in the pharmaceutical sector, especially for pay-for-delay cases. Also, regarding standard essential patents, I mean, also the issue of portfolio licenses, because standard essential patents are never licensed on an individual basis, but are always licensed as a pool, even by individual licensors. I mean, this is something that might benefit from some clarification. Also, there is the issue besides, let's say, some new forms and in novelties in technology pools, but the issue that emerged in Germany last year in summer of the so-called licensing negotiation groups. And so not just licensors coming together to pool their IP rights and in a pool and then license these to third parties, but implementers coming together to negotiate collectively a license to a technology that they all need. So this issue might deserve an ad hoc space in the guidelines, because the experience is still limited to like for having a direct block exemption. But still, I mean, the opportunity was missed in the horizontal cooperation guidelines while talking about standardization agreements. Also, you might know already, but the draft standard essential patent regulation that the Commission put forward 2 years ago, I mean, has been essentially withdrawn. So we will not have this regulation specific to standard essential patents. So also, I mean, that is another missed opportunity to clarify a bit the law, the competition law, at least on licensing negotiation groups. And so the guidelines are the best shot that the Commission can have to provide clarity, some clarity. And of course, I mean, the last issue that will deserve update is the one of digitalization. I mean, data is much more important than 12 years ago. We have much more data sharing agreements. We have more laws regulating the transfer of data between private companies, between government, and so on. And so also more data-related provisions in licensing agreements. So the stakeholders have asked essentially the Commission to clarify when can data qualify as a technology right and so benefit of the block exemption. Of course, under certain circumstances, data can be know-how, can be a trade secret, but not all data can be a trade secret. Not all data sets are identified. Not all, like many data sets, it's not known what's inside. They are almost black boxes, so it's difficult to apply trade secret protection. And so let's say some level of clarity on when data can be benefit of the block exemption when included in the technology transfer agreements. Some brief conclusions. So technology transfer, essentially bilateral IP licensing and some IP assignment agreements. There is an ad hoc regime that covers both horizontal licensing agreements between competitors and vertical ones. The regime, let's say, is more lenient for vertical agreements between non-competitors. The 2014 legal framework is quite common and similar to the other block exemption regimes. You have the regulation with 2 requirements: market share thresholds, then a blacklist of ARCO restrictions that exclude the benefit of the block exemption for the entire agreement, and then a few excluded restrictions that are severe from the block exempted agreements, but still can benefit from an individual exemption. Then the guidelines that provide guidance on applying the TTBER in the scope of application of the regulation itself, but also provide some insights on the application of competition law to those types of IP licensing issues that are outside the block exemption. So, for example, technology pools as a multi-party agreement is now within the block exemption, but still is assessed under the guidelines. The regime, I mean, new regime expected mid next year. No overall of the current regime, also because the licensing practices have not really changed that much. But at the same time, clarification of when data issues are covered by the block exemption, account of pharmaceutical case law developments that will be touched especially tomorrow by Professor Arezzo, and also an expectation of a new section on licensing negotiation groups. So thank you for your attention.